Good morning and welcome to another council tax video. In this council tax video we are going to investigate whether or not your property is in fact taxable. I've received a notification that somebody disagrees with my assessment that your property is not taxable because it's a private property, and it is domestic property versus non-domestic. So I'm going to go into the inner workings of a couple of different acts, and we'll investigate whether or not your property is in fact taxable. Now, I'm not going to read every specific screen. I'm going to leave that up to you because there is quite a bit of information here. There's approximately 45 slides in this presentation. I'm just going to talk, and I'll leave the screen on the video here for a few seconds, and if you need to, you can pause and look up the relevant information. And I would suggest that if you are viewing this in the efforts to deal with council tax, that you write down the appropriate sections and download the current act, or in some cases the original act, to see what's what. And from that you can draft your documents to basically try to attempt to put forth the legal arguments that the property that you live in, as long as it's your primary place of residence and not used for business, is in fact non-taxable. This is the fourth in a series of videos, and as I do further research and get precedent case law, I will be following it up with future videos. Well, one of the things that we note from one of my previous presentations is that the council tax is not something to be adjudged. That's covered in a previous presentation. So if it's nothing to be adjudged from a court, then the court can't issue an order, and likewise the council can't issue an order, so therefore nothing they do falls under the Bills of Exchange Act. The Bills of Exchange Act is an unconditional order in writing addressed from one person to another, signed by the person giving it, requiring the person who had addressed it to pay on demand or at a fixed or determinable future sum. Now, as we both know, council tax is typically 1 year to pay out your council tax bill. However, if it's not to be a sum adjudged and they don't give you a actual bill because there's no contractual agreement, then what they're dealing with is a presentment, which some people may look at it as an offer. However, it gets much deeper than this. When you deal with council tax, you find out that the council tax does not deal appropriately, especially if you go to a council tax hearing. It's done typically in private. You're told not to attend the court, which is court hearings are supposed to be public. There is no court file number, and courts have no record of it. And I've actually done some background research for a particular person and found out that there's not even a conviction. So in 1995, the first committee report established an initial version of the 7 principles of public life, and therefore these principles would apply to not only the local council but also the court. Okay, the principles were selflessness, integrity, which the municipality and the court don't have any. The objectivity, they don't have any, because if you read your council tax notice of liability, they don't even provide you a way to present any arguments as to why your property may or may not be taxable. There is no accountability, because if you ask for a copy of the budget or any other details from them, they will typically tell you they provided sufficient information, and it may or may not even address what you've asked for. They're certainly not open, and they're certainly not honest, because they're having these fraudulent court cases where they hire the courtroom, and it's just the way it is. Now, if we go back to the creation of government, we have to look at the Local Government Act 1888, which, if you remember from my previous presentations, we were doing a explanation on what I call primary legislation. But here we see on the first line on section 79 sub 1, the council of each county shall be a body corporate by the name of the county council. Okay, so that fixes that problem. So now that we know for a fact that these corporations masquerading themselves as being a council are in fact body corporate, there is a Clearfield doctrine, and among the Clearfield doctrine, one of the main principal arguments is if you are operating as a corporation and you're interchanging money, then you have no more and no less rights than any other corporation. So I would bring up the argument that if a corporation can't compel you to a obligation without some sort of an agreement or contract, then how can the local government do it? And then the other thing it says under 79 sub 2, all duties and liability of the inhabitants of the county shall become duties and liabilities of the council. So therefore, why would you as an individual operating in private have any obligation to the municipality? In fact, there is precedent case law that verifies that, which I did not include in this presentation. And then there's other things within here. So I suggest everybody read Local Government Act 1888, Section 79. You can pause the screen if you need to and capture what's required for your particular case. Now, when we go to the Local Government Act 1972, we see that there's been some amendments, and that's what's done in the brackets there. But if we look through this thing under 1, it says there shall be a council consisting of a chairman and councillors. Council shall have all functions as vested in them by the Act or otherwise. But we also know that the councils don't necessarily follow the Acts. For every district there should be a council consisting of a chairman and councillors, and the council shall have all functions vested in them in this Act or otherwise. Well, because they work for a council, which is now a corporation, they have no allegiance to you. They only have allegiance to the council and therefore the shareholders, and to make profit. Now under section 2, where it says 2B, in such case references this act, a member of council in reference to the elected mayor of the council. Well, who elects that mayor? I would draw your attention to the fact that if you had control of a group of individuals, do you honestly think they're going to let anybody from the outside public influence or potentially damage that relationship? And then it says under section 2B, sub B, the chairman of the council or the councillor and the council. So this would indicate to me that the council is actually electing its own people, and there is no independent third party when it comes to the voting or electing of individuals who work for that corporation. Let's stop calling it a government. It's actually a corporation. So that's the one problem. And then it says under 2 sub 3, each council mentioned in sections 1 and 2 above shall be a body corporate by the name. So again, it confirms that they are in fact a corporation. Now this brings up another problem, that if you want to sue a corporation, you're best off to try and get a name of somebody within that corporation. And if anybody's gone through an appeals process, or in fact gone through a, let's start at the beginning. If anybody's gone through a council tax hearing and they didn't get satisfactory results, you do have the option to attempt an appeal, or in the alternative you can do what's called a judicial review. And even if those 3 options are exhausted, there is an alternate remedy, which I haven't discussed because I want to test it out, and I know a specific individual that requires this information, and once we verify that it works, then we can basically make it public knowledge. Now keep in mind, when you challenge any corporation, they're not going to want to admit that they've done wrong, And also keep in mind that the council has confirmed that they hire the local court to conduct their hearings. Well, that already creates a conflict of interest, and is in violation of the Nolan Principles we discussed earlier, as well as Senior Courts Act and other statutory requirements regarding the conduct of the court. So we already know that the council tax hearings are tainted. Well, there's 1 and then A through E. And again, we go back to number B, or letter B, is not the sole main residence of the individual. So your property is non-taxable if it's your private dwelling space. Now here again we go through section 3, sub 3, and again we come down to section A. The condition mentions in sections 1A through D above. We just went through that. And again, if it's not your sole place of residence. So I don't think there's any argument now that your property, if it's your sole place of residence and not used for any sort of commercial activity, there should be no question that it's non-taxable. Now, if you did in fact pay a council tax bill, or if you went through an appeal and then you appealed the appeal, or you went through a judicial review and or did a judicial review and an appeal of that judicial review, there is a remedy which we can exercise in order to try and get those fines or levies or taxes, whatever you want to call them, returned back to you. This is very important, and I know of a particular case where this happened, and the person apparently didn't argue the point, or it was disregarded at the court level. I don't know. I haven't got a transcript of that case, but I am willing to assist that one person. And in fact, I'll assist anybody, but this one person is a specific case I was involved in, and I would like to see them get a remedy. So now under Local Government Finance Act 1988, again, Section 3, and then Sub 4, again it comes back to A, the conditions mentioned in subsections 1A through D above, and again that confirms yet again that if it's your sole place of residence, it's non-taxable. And again, if we go to the Local Government Finance Act 1988, Section 3, Sub 5, again we go to A, and the conditions mentioned in subsections A through A and B above. Okay, so again we basically beat the thing to death. Your property is non-taxable. Now, if we go to the Local Government Finance Act 1988, Section 4, and this is Section 4, it gives you the definition. Okay, so if we go through the definitions, which are typically found at the front of any sort of act or statute, and for ease of transparency, act and statute will mean the same thing. Now it says interest means legal estate. So when we were talking before, your property, if it's under a mortgage, that would be legal, and it would be an estate. Furthermore, if you've paid off the property and it is in fact in your name, again it would be an estate, so you can use that. Relevant leasehold interest is an interest under lease, or under lease which was granted in term for 6 months or more, conferred the right of exclusive possession throughout the term. That would fall under a mortgage contract. It may also fall under a renting contract if you're a tenant and there's a landlord. And then under Section 4, a building that is self-contained part of the building is domestic property if it is used wholly for the purpose of living accommodation. So again, we've now fixed what domestic property is versus non-domestic. And then 5, a building or self-contained part of a building is not domestic property if it is wholly or mainly used in the course of a business for the purpose, provisions of an individual whose sole or main residence is elsewhere, of accommodation for short periods, together with domestic services or other benefits or facilities. So we can see here that there is a difference between domestic property and then the building, which is used for commercial. And then in construction with sections 4 and 5 above, anything anything not in use shall be treated as domestic property if it appears that when it's next used it will be domestic property. So if a property isn't being used, i.e. it isn't being lived in, and say it's a vacant property, you know, no longer living there for part of the year, or if it's in fact looks like it will be used for domestic property, which is private property basically, then your property should be redefined as that, and you can ask the local authority to remove the penalty on your property. You would write to the valuation officer, which is a section 13A officer within your local band, and that would solve that problem potentially. I say potentially because we never know what these people are going to do. And then it says the Secretary of State may by order amend or substitute another definition for any definition of domestic property for the time being effective in the purpose of sections 3 above. Well, we don't deal with the Secretary of State, and I don't think the local councils do either. And then under number 8, a self-contained part of a building is part of a building used or suitable for use as a separate dwelling. And that would you get into the case if you had an apartment building or a common building where 2 or 3 or 4 or more private dwellings were used. But you can definitely, because you have a separate address for each one, you know, unit number 1, unit number 2, unit number 3, you would be able to go then and use the arguments presented within this presentation to further make an argument against your council tax. Now keep in mind that the statute has more authority than the municipality or council, and the statute also has more authority than the local court, magistrate's court or county court. And again, I can assist people if they have an issue regarding council tax or a court process. The paperwork in this presentation is to supplement the 3 previous presentations I've done regarding council tax. Now, if we go to the Local Government Finance Act 1988, Section 4 again, under Section 9, because we're still in the definitions, it says owner in relation to a caravan. Now, one may argue the point, well, what does that have to do with council tax? Well, what they're trying to do now is actually tax people that live in a caravan or basically a home on wheels. And this would also probably apply to someone who had a larger tent camper. However, because it's not technically a building, you would have some argument at that point, because a building is not portable, whereas a caravan or a fixed-up vehicle for primary residence is in fact mobile. But anyway, an owner in relation to a caravan is subject to an agreement for hire, purchase, or conditional sale, the person in possession under the agreement. Well, because your caravan, if we want to call it that, is not for hire or for purchase or for conditional sale, that would give you an exemption. And then under B means if the subject bill of sale or mortgage, the person is entitled to the property in it apart from a bill or mortgage. And this goes back into what we were talking about earlier. And then under Section 10, they define land as a protected site at any time, if at the time it's protected site for the purpose of Part 1 of the 1968 Chapter 52 Caravan Sites Act, and I'm not going to get into that unless there's a demand for it. And then under Section 11, where a building is situated in the area of 2 or more authorities, it and each part of it shall be treated as situated in the area in which the greater or greatest part of the building is situated. And this happens because your property may be partially on a property line that's between 2 different counties. Okay? But again, that's probably not applicable to most people. Now, how is your property classified? We're going to get into this now under the Local Government Finance Act 1988. Domestic property, they're specifically telling you right here, domestic property is domestic if it is used wholly for the purpose of living accommodations. And so, and then under B it says it's a yard, garden, outhouse, or other belonging to or enjoyed with the property falling within paragraph A above. And then it says B is a private garage, so they're differentiating between a private garage and one used for commercial, which would be in a public business. Anyway, it says a private garage used for the accommodation of a private motor vehicle. And then under D, private storage premises used mainly for the storage of articles for domestic use. So this again clarifies there is a difference between domestic property, which is your primary place of residence, and then non-domestic property, which would be commercial. And then if we go here under number 2, property that is domestic property if it's wholly or mainly used in the course of a business for the provisions in an individual whose sole or main residence is elsewhere. Okay, so property is not domestic if it is if your main residence is elsewhere. So this again confirms that there is a difference between domestic and non-domestic. And then it says a pitch caravan is domestic property if one or both of the following conditions are fulfilled. And then it says A is part of a site where it is a protected site, or B is occupied by a caravan which is the sole or main residence of an individual, consisting of sole or main residence in accordance with section 2 above. So again, this again goes back to the private property thing I mentioned in the previous slide. And then it says under number 4 is the mooring domestic property occupied by boat and the sole main residence of an individual. So even if you have a boat that you live on, perhaps a sailboat or whatnot, again it's your main residence and therefore it's non-taxable. And this is under section 66 of the Local Government Finance Act. Now, how is my property classified? Again, Local Government Finance Act 1988. And then it says here, property is not used for domestic if it appears that when next in use it will be domestic. Okay? So again, applying subsection 5 above, assumes it may be a site which is not a protected site and will become one. And then under 7, whether anything in a caravan shall be constructed in accordance with Part 1 of the 1968 Caravan Sites and Controlled Development Act. I'm not going to get into that. Whether a site is protected shall be construed in accordance with Part 1. Again, I'm not going to get into that. Secretary of State may order or amend or substitute another definition for domestic property, but right now this is what it's defined as. And when it says the Secretary of State may do it, that doesn't mean your local council can do it, because they don't have the authority of the Secretary of State. So given that information, we are well on our way to proving that domestic property is not the same thing as commercial. Now, Local Government Finance Act 1992, meaning of a dwelling. This section has an effect for determining what is a dwelling for the purpose of this part. Now, subject to the following provisions, a dwelling is any property which, by virtue of definition of hereditament under section 115 sub 1 of the General Rates Act, would have been a hereditament for the purpose of the Act if the Act is not remained in force. So therefore, even though that Act may be repealed, they don't care. They're saying that the Act is basically equivalent to being active. Now, keep in mind that a hereditament is typically a property which is hereditary or is inherited. For those that don't know what hereditament means, you can dig into that further. There is additional explanations, but I'm trying to keep things fairly simple. Okay. Now it says is not for the time being shown or required to be shown in the local or central non-domestic rating list in force at the time. Well, right there, your property is already not classified as non-domestic. In fact, it is domestic. And then under C, it said is not for the time being exempt from the local non-domestic rating. Again, that doesn't apply to you because your property is domestic. And then if we go on to C, is not for the time being exempt from the local non-domestic rating for the purpose of Part 3 of the Local Government Finance Act 1988. We've already went through that. And then in applying the paragraphs B and C above, now pay attention to this. No account shall be taken of any rules as to Crown exemption. Okay, well, the Crown's already exempted your property. So there, because your property is your primary place of residence, we'll make that assumption for the explanation of this presentation, and therefore we've already established that it's non-taxable. Therefore, it doesn't need to be listed in the Local Government Act or the local council. Now, for those that wish help, I will point you in a direction privately that we can use to remove your property from the local taxation scheme. I'm not going to produce a video for that because I need people to do it in mass, and if I produce a video that would explain how to do it, then the local government and or the Secretary of State would take the appropriate countermeasures to basically thwart my efforts. Now, the Local Government Finance Act, again, 1992. Now it defines what it is. A rediment which is composite rediment for the purpose of Part 3 of the Act, 1988, and would still be such a rediment if paragraph B to D in section 66(1) of that Act, domestic property, were omitted. And then it's also subject to subsection 6 below, dwelling for the purpose of this part. So they are differentiating again between commercial property and non-commercial property, which is domestic versus non-domestic. The Local Government Finance Act 1992, 4 subsection, subject to section 6 below, none of the following property. And then they're talking about what's taxable: a yard, garden, outhouse, or other belonging to or enjoyed with the property used wholly for the purpose of living accommodation, or a private garage either has a floor area of not more than 25 square meters or is used mainly for the accommodation of a private motor vehicle, or C, private storage premises, which is used for the storage of articles for domestic use, is a dwelling insofar as it forms part of a larger property, which is itself a dwelling by virtue of subsection 2 above. And we've already seen that dwellings, private property, for your primary place of residence is non-taxable. So that should put an end to that. Now, this has been modified. That's what you see, the F to F is a revision. Section 4A, subsection 6 below, domestic property, falling within section 66(1)A of the 1988 Act, which we've already gone through, is not a dwelling except so far as it forms part of a larger property, which itself is a dwelling by virtue of subsection 2 above. And then the Secretary of State may provide that such cases may be prescribed or determined under an order. Anything which, apart from the order, would be a dwelling shall be treated as 2 or more dwellings. Anything which, apart from the order, would be 2 or more dwellings shall be treated as 1 dwelling. So basically, unless the Secretary of State changes the paperwork, your property is non-taxable. The Secretary of State may order, amend, or define the definition of dwelling, and for the purpose for now, this is what it currently is. Now, we go to the Local Government Finance Act, again, 1992, subsection 4, dwelling chargeable to council tax, and it says council tax shall be payable in respect to any dwelling which is not exempt dwelling. Chargeable dwelling means a dwelling in respect to which council tax is payable. Exempt dwelling means any dwelling or a class prescribed in order by the Secretary of State. So we can now see that there is in fact 2 definitions of dwellings, but based on our previous information, we know that if it's your primary place of residence, it is not a chargeable dwelling. So if it's not chargeable, it's not taxable. For the purpose of subsection 2 above, a class of dwelling may be prescribed by reference to such factors as the Secretary of State sees fit, and we will draw the conclusion that the Secretary of State had something to do with the statute. And then it says, without prejudice to the generality of subsection 3 above, the class of dwelling may be prescribed by reference of 1 or more of the following factors. And again, they're clarifying the physical characteristics of the dwelling, and then that would go back to the square footage of the garage, if you had one. It would also go to the the makeup of the property, and then B, the fact that the dwellings are unoccupied or occupied for prescribed purposes, or occupied or owned by persons of prescribed descriptions. So I will elaborate on this. The fact that the dwellings are unoccupied, which would mean they were subject to no tax if it was private property, or less tax, or are occupied for a prescribed purpose. Again, that would differentiate whether that purpose was for private use, in other words your private place of residence, or for commercial or semi-commercial use. And that's what they mean by that. Now it says Local Government Finance Act 1992. Again, we're dealing with dwelling, which is your home. Person is liable to pay council tax. The person who is liable to pay council tax in respect to any chargeable dwelling. Well, we now know from our previous talk that we are not in a chargeable dwelling, so we don't have to worry about that. Okay? And then if we go under section 2, I'll just elaborate a little bit. He's a resident of the dwelling and has a freehold interest in whole or in any part of it, and such a resident and leasehold interest which part of the dwelling is not inferior to another such interest held by a resident. He is both a resident and a statutory introductory tenant of the whole or part of the dwelling. In the case of the dwelling in Wales, okay, where the person, such resident, has a tenancy in whole or part of the dwelling, which is a secure contract or an introductory standard contract. Such a resident's contractual license to occupy or any part of the dwelling. Well, you wouldn't have a license to occupy your primary place of residence. That would be commercial. And then, so we can see here from the Local Government Finance Act, Section 6, we're not in a chargeable dwelling. That should solve that problem. And then if we go to the Local Government Finance Act 1992, financial provisions, there shall be paid out money provisions by Parliament, any sum required to enable the valuations to be carried out with parts 1 or 2 of the Act, any expenses of the Secretary of State incurred in consequence of the Act, any increase in attributes attributable to the Act in the sums payable out of money so provided under any enactment. And then under number 2, there shall be paid in the consolidated fund any sums received by the Secretary of State in consequence of the Act, and then any increased attributes in the Act sum payable to the fund under any other enactment. So if we analyze this, this is telling you that your Local Government Finance Act is actually paying into a consolidated revenue fund, which is what I stated in the previous correspondence. And then there, it says here there should be paid out of money provided by Parliament any sums required to enable evaluations to be carried out in accordance with Part 1 or 2 of the Act, any expenses of the Secretary of State incurred in consequence of the Act. Well, this would draw your conclusion to the fact that you can actually go after the government, and there is proceedings against the Crown Act, which I covered in the previous presentation, so there is a remedy for that as well. And because we have this 115 section, we can now use the section 115 because there's got to be an officer involved, and we can hold that officer accountable for the misappropriation of funds. And then if we go under the General Rates Act, which we referred to earlier, context otherwise requires, the following expressions have the following meaning, and it says agricultural land, charge, clerk, commissioners, and dwelling house. And dwelling house means a hereditament which, in accordance with Section 13, or Schedule 13 of this Act, is used wholly for the purpose of a private dwelling or private dwellings. So we can define our property, provided it's not used commercially, as a dwelling house, and or we can call it a hereditament if it's going to be inherited by somebody down the line. Now, expected rate, any rate which is associated under commission of sewers, respect to any drainage, embankment, or other work in benefit of the land. Well, if you're on private property, unless you're getting a bill for services rendered by the municipality, that would be another argument if you're on private property with your own well. And then the church rate is something different. Rate which is levelable by conservation of common, well, that doesn't apply to most private homes. Any rate payable by a consumer for supply of water. Again, if you're on a well, you don't need to worry about that, and you probably get a separate water bill anyway. Any rate of a description, commonly known as the garden rate or square rate, levied by any persons other than a rating authority. And again, that wouldn't apply to most people's homes, provided it's private property. Hereditament means property which is or may become liable to a rate being used for such property which is or would fall under, shown as a separate item in the valuation list. The valuation list, again, is the I think it's 5 separate bands where they rate your property under certain taxable rates based on where you live. And then the local act includes provisions confirmed by an act of Parliament. Well, none of the acts have gone through Parliament and passed by the Crown because that ceased to happen many years ago. It says the minister means subsection 2, Minister Housing and Local Government. So again, we have a name now we can go after. Now, I had suggested that we fill out a FOIA request to one of the people I was helping in assistance with council tax, and rather than take my advice, they disregarded it. And had we done this, we would be much further ahead, but the customer is always right, and therefore you generally do what the customer wants and then deal with the consequences thereafter. So now that we have this information and some additional information, we could actually use a FOIA request to end this council tax provisions with the information presented within this presentation. Again, if we go back to the General Rates Act 1967, owner and accept in conjunction with Section 4950, 55, and 56 of this Act, and Section 60 of Schedule 1 of this Act, means a person for the time receiving or entitled to receive the rack rent of lands or premises in connection with the words used, whether its own account or as an agent or trustee for other person who would receive entitled to receive the rent if the lands or premises were on a rack rent. So this is applying to commercial, because if you're receiving rent, I didn't say receiving mortgage, now I did say rent. If you're receiving rent, then your property is potentially commercial. But there is a way around that as well. Under Section B, in connection with Sections 49, 50, 55, and 56, means a person who is, or if the hereditament in condition which the word is used were occupied, would be entitled to receive rent payable in respect thereof, or were that the hereditament is occupied free of rent by the person whose premises is so occupied. So you have to read through that and figure out if that applies to you, but again, rent is commercial. Prescribed means prescribed by rules made under Section 113 of the Act. You'll have to go look that up. Profit basis, again, that would be commercial. In relation to valuation of a hereditament means the assertment of value that is hereditament by reference of the accounts, receipts, or profits undertaken carried on therein. Again, this is alluding to that you're dealing with commercial property, and therefore the General Rates Act 1967, so far from what we've looked at, does not apply to a private dwelling. Now, rate is subject to Section 2 sub 5 of this Act, and except for Sections 1 or 2 of the Act, an expression expected rate means a general rate in the application of Part V1 of the Act. In the City of London includes, and that gives a certain area, rate made by levy of Common Council, no corporation, city, under the powers transferred to them by Section 1910. That's London Truths and Rates Act 1910. So we don't care about most of that. And now again, usual tenants rate refers to on the second last line in this Act. Again, a tenant is somebody that's probably renting property for commercial purposes. General Rates Act, a period means 1 year or part of a year which the rate is made. Ratepayer means a person who's liable for the rate in respect to property entered into the valuation list. And rating area means rating authority in accordance with Section 1 sub 1 of the Act. But again, we all now know from looking at this this Act that it doesn't apply to a private dwelling house, private property. Now, rating district in Greater London means rating area subject to Section S1 sub B Schedule 4, and we've already went through that. Includes any part of the rating area which is subject to otherwise in respect of a garden. I don't know what CR means. Square, provisions of London and Title Rates Act 1910, 1947, City of London Act 1947 to separate ratings. Again, that wouldn't apply to us because we're not in that area. Relation to any other area subject to alterations made, provisions of any act. Okay, any act would apply to all acts, and we all know now that private dwelling houses are non-taxable, and then it's talking about a church. So now rebate application. Now keep that in mind. Rebate means you're entitled to a refund. And under Section 49 of the Act, rebate period means in assigned Sections 49(1) of the Act, which is typically a year. Temples means the inner temple and middle temple. Again, that's got nothing to do with us. Valuation list in relation to a rating area means a valuation list maintained for an area under Part V of this Act. Again, we now know that that doesn't apply to us. Valuation list in relation to any rating area means a valuation list maintained under the area. Again, it doesn't apply to us. Valuation officer in relation to a valuation list. So that would mean now we could potentially build a claim against the valuation officer in the valuation band, the VOA office, which I've discussed earlier in a previous presentation. An area premises any officer or commissioner who for the time being appointed to the commissioners by valuation office or one of the valuation officers to be deputy valuation officers or one of the deputation value officers in relation to the list, the valuation list for the rating area or the valuation list for the rating area whose those premises are situated, as the case may be. Year means a period of 12 months beginning with April 1st. So now we have two people we can go after. We can go after somebody at council, and we can go after somebody with the valuation office. Now, rights to rebate. In respect to rates of dwelling, any person in section applies, makes an application. Okay, so that would be my first step if I was doing this. Shall be subject to subsections 2 and 7 of the section and section 16 sub 2 of the 1968 Rates Act. Minister of Social Security Act, entitled to respect a period of 6 months beginning April 1st or 1st of October in any year hereinafter of the Act referred to a rebate period. Now, given the fact that fraud doesn't have an expiration date, anybody that has property that's been taxed incorrectly or unlawfully would be entitled to get that refund. Okay, because fraud doesn't have an expiration date, and fraud destroys all that it touches. And then it talks about 5 shillings and composite pound application revocable income. We don't use that anymore. General Rates Act 1967. Again, the applicant did not become entitled to make a rebate application after the beginning of the rebate period which it relates, which is incorrect because, as I said, fraud destroys all that it touches. If you want to pause the presentation here, you can capture the rest of what this is. I'm not going to go through it. Again, here it talks about the person who's the occupier and resides or is usually resident of a hereditament is a dwelling house. Okay, so they're again differentiating between a dwelling house, which is private, versus commercial. Again, you'd have to read the General Rates Act 1967. And it's talking about rebate applications, so you have a right to get those funds back. Again, pause if you need to read this. Pause again if you need to read this. Pause again if you need to read this. Now it says General Rates Act 1967. Any person with the intent to obtain a rebate under this section would get into some hot water if they furnish any information which he or she knows to be false in a material particular or withholds material information. Shall be liable on summary conviction to a fine not exceeding £50 or to imprisonment for a term not exceeding 3 months or both. Well, I don't think you'll be going to prison unless you do something majorly wrong, because prison is usually only applicable to a criminal court case. And although furnishing false information is perjury, and so it technically is criminal. If you make a minor mistake, that's one thing. If you outright lie to misrepresent, well, that's another problem. Now, you could also take this General Rates Act and apply it in reverse and say that the taxing authority, the valuation band, and or your local council did in fact furnish false information and a material particular, or withholds material information, because they're supposed to be the ones administering these statutes, aka laws, and they should know what's legal and what's illegal. So you can now use this General Rates Act against them. Now it says, without prejudice to any other right to recover the amount, any relief by made of a rebate order under section which has been wrongfully afforded, where a person is convicted of an offense under subsection 8 of the Act, so a result of the offense being afforded such relief which he was not entitled. And then it carries on. Okay, you can pause this to read it. Again, pause this if you to read it. Now we go through a court case here, and because this is getting rather lengthy, I didn't expand on it any further. But in this Martin and Orrs, versus Hewitt, they went after a valuation officer in 2003, and so the applicant sought the deletion of entries in the list, claiming that their boathouses were domestic properties under Section 66 of the Local Government Finance Act 1988, and thus not rateable. Now, we started out talking with the Local Government Finance Act 1988, 1988. Now, the Valuation Tribunal held that the boathouses were rateable, which means taxable. The boathouses have been occupied by the Martins since 1998 and were located a little less than a mile from the Caravan and over 50 miles from their home. Mr. and Mrs. Ravel owned a freehold of both the house and the boathouses on two separate deeds, so therefore it's two separate properties. So if it's two separate properties, they would have to be assessed separately. So this is what happened. Legal issue. The legal issue is whether the boathouses qualified as domestic property under Section 66 of the Local Government Finance Act 1988, and whether the boathouses were considered as basically outbuildings or outhouses within the meaning of the provision, whether the boathouses were within the curtilage of a house. Okay, those were the three legal issues that were brought into the case. Now the arguments. Mr. Scrafford argued that the boathouses could be considered outhouses or other occuprances, emphasizing functions over location within the curtilage of a dwelling. And again, I stated that there were two separate pieces of property. Mr. Mould contended that the Caravans were not domestic property based on the specific provisions of the Act, and the county court judge initially held that the lands and buildings were part of the house by force of definition of the decision, which again was later overturned by the Court of Appeal. So this proves now that the Court of Appeal is in agreement with me, because there were two separate pieces of property. They were not taxable under the same definition, and therefore the person was granted their appeal, and therefore the property is non-taxable. Now the precedent, this meaning the principle of law, the rating was discussed in Climo VO versus Shell-Mex BP Limited. The previous decisions restricting the apparatus to the curtilage of a house. So they basically found it in favor. Now, decision. The Valuation Tribunal ruled that the boathouses were rateable and they were not within the curtilage of a house. The court held that the tools and equipment and other items found in the premises disqualified them from being considered for domestic use. Now, I don't know what those tools were, but a person that has a property can have a certain amount of tools. You know, you fix your lawnmower and other small items. Now, the appeal was allowed, and the entry from the list were ordered to be deleted. And by list, they're talking about the valuation list. So therefore, the property was deleted from the valuation list and therefore no longer taxable. The question of cost was left for further submissions by the parties, and I don't know what happened, but the appeal was granted, and the property was in fact removed from the valuation list, which proves what I stated earlier under Section 66 of the previous Act of 1988 do in fact hold true, and there is a differentiation between property which is taxable and non-taxable, and there is a remedy, or at least potential remedy, within the legal system. I was informed that a certain individual said that I was incorrect, and I've made this presentation, which is now going on to quite some time, to prove the point that I was correct in my statement, and also to provide some hope to the viewer who may be wishing to challenge council tax and the validity thereof, as well as the conduct of the court. Conclusion: the Cumbria Valuation Tribunal decision that the boathouses were rateable due to not being within the curtilage of the house was upheld. The court also ruled that the items found on the premises disqualified it from being considered for domestic use. The appeal was allowed, as I said. The entry into the list was ordered to be deleted, pending further submissions and costs. So the person did in fact win their argument, and there is a difference between a dwelling house and a commercial property. I'm currently working on a book regarding council tax. If you wish to be notified when it is complete or have any other comments or questions, I can be reached at that email. I thank you for taking the time to listen to this presentation, and I hope you found it helpful. And if need be, go back, rewatch it, pause where you need to, write down the appropriate subsections, and read the acts and understand them. It doesn't do any good to try and walk into court with a script, because they'll ask you a question and you will be scrambling around looking for the answer, which if you don't know your own case, you will probably not win. Now, some people have asked me, is it possible that I can step into court and go into court for them? And the answer to that is no. The court doesn't allow me to do that. I've already checked into it. So if you wish to challenge council tax, make sure your paperwork speaks clearly as to your arguments. Because with any court case, your judge or magistrate or clerk or however that looks at your paperwork should be able to comprehend what you're trying to say, and keep in mind that you may not be able to present your arguments all orally. In other words, you can't verbalize it in the court. The court may not allow you the time to do it, and you may not have the wherewithal to do it because you're now under pressure speaking in front of a judge. Therefore, your paperwork should be written clearly and concisely on a point-by-point basis and present the facts contained therein, and from that they should be able to render a verdict, and you can clarify any specific points that are needed if the presiding judge or magistrate doesn't comprehend what you've tried to put forth. And keep in mind that your paperwork should be clear and concise and complete, because the courts are obligated to render a verdict based on all the information presented, both orally, verbally in other words, and also what's done in writing. Now, if you wish to challenge the outcome of a court case, you can only do so if there is an error made by the court or an error in law. If you don't present your case well in writing and you're unable to present it verbally, there may or may not be an error that was presented to the court, and therefore if there's no error presented to the court because your paperwork's incorrect or not complete and you were unable to verbally present that fact, you will not be granted your chance to do an appeal. This is why I state that your paperwork should be very concise, done on a point-by-point basis, and if the judge does try to shut you down, as long as that information is clear and concise in the written paperwork, you will have a chance at an appeal or a judicial review. Now, I made reference earlier in this presentation to a court case, and I told everybody that I have a potential remedy. Now, one of the things that they will typically do in a court is they will try to shut you down because they don't want you to present your defense to any sort of case. However, you can always go back in a different way and go in as the plaintiff. and based on that we can present another separate case where the counsel is now the defendant in a case. Anyway, I hope you found this information useful. We're getting on to almost an hour, and I don't want to run it too much past that. If anybody has any questions, reach me at that email address, and I'll see if I can point you in the right direction. Thank you, and have a great day.